Hi, everybody. Nice to see your faces tonight. I'm really excited about this week. Federalism, to me, is one of the most interesting topics when you deal with American government for a number of reasons. One, that it's really unusual in terms of world governments that are democracies or republics. So we're real different in that way, and there are historical reasons for it, and there are power reasons for it. So I'm excited to hear tonight what Shayne's going to do with that. And then you haven't heard from Chris Cavanaugh yet, but I think you're going to love this. He's going to be dealing with one of the three branches in particular, and that's the executive branch. And I think when you look out at the world today, people are, hey, what's going on with the executive branch? Can the president do this? Can he not do this? What's Congress's role? Is the presidency what we want? Is it something that was historic and now it's changed? Anyway, that's the second half. So without further ado, Shayne, I'll turn it over to you, and let's have fun tonight.
All right.
Hi, everybody. It's nice to see you all again. Tonight we're going to be, as Bob said, talking about federalism to start. As Bob was saying, American federalism can be really hard to understand from the outside, right? We get it sort of at this sort of visceral level because we live it. But if you've ever tried to explain it to someone from another country, it gets pretty hard to do, right? It's like trying to explain baseball to a European, right? They get really lost, and it's hard. So, because it's not a unitary system, right, where power flows from the national government to local administrative units. It's not a confederation where power flows from the states up to a federal government. It's a system of different levels of government, all based on popular sovereignty that have, overlapping powers, right? So I'm going to ask Mark to share some things with you. We're going to start with this little PowerPoint I've created. And the second slide in the PowerPoint is this little Venn diagram. And for those of you who are teachers, I wouldn't be surprised if it's something that you use with your students. But I thought we'd just take a minute and kind of, just start with like what goes in each space, right? So the idea, of course, of a Venn diagram is that things that are solely federal responsibility go on the left, things that are a combination of federal and state where they share concurrent powers of some kind go in the middle, and then what solely a state responsibility goes on the right. So let's just take a minute, look at the diagram, and I want you to try to come up with one or two things that might go in each of the sections of the diagram, okay? So let's think for a second, maybe jot some things down, and then I'm going to ask you in a minute to throw some stuff up in chat. So what's just the job of the national or the federal government there? What would you put on the far left there? Great, coining money, weights and measures, I see. What else you guys got that goes just from federal? Got lots of defense, declaring war, absolutely. International trade regulations, immigration, good. Tim's trying to be provocative here with marriage, but we got some things there on the, some ideas for what goes in the federal side. What goes in the middle? What's a concurrent power? We've got both federal government and the states exercising power. Taxes, yes. Education, yep, good. Drug laws, police powers, okay. Roads are good, is a good example, right? Whether it's how, providing federal government providing highway money, states funding roads, good. All right, now what I think is the hardest one, let's go to the far right. What goes in just states? Only the states can control this thing. All right, so we've got things like hold elections for states, right? So that's true, but federal government has something to say about elections in the sense that the Constitution requires that you allow certain kinds of people to vote. There is some things in the Constitution about when you hold elections for Congress, especially. Got driver's licenses, but if you live in a state where they're not going to accept your driver's license at the airport anymore, is the state really going to still completely control what's on the driver's license, or is that now somehow federally regulated to some extent? Garbage pickup. Yeah, that's a good one. Trying to think if there's any way that the federal government might intervene in your garbage pickup. So marriage laws, we've now got some federal, the Supreme Court has said, that states may have wanted to define marriage a certain way, and they're not allowed to do that anymore, that we have same-sex marriage legal across the United States. Yeah, I mean, drug laws is interesting. So what, if we sort of tried to imagine this chart over time, right, we would probably imagine it starting with a much bigger state circle than is there, or maybe more skewed to the right with more just state responsibilities, and the federal government kind of sliding over maybe and encroaching upon the states, right? That's probably what the image we might want to imagine here. So, the question kind of becomes, how do we get here? So I'm going to sort of take us back to kind of how we got here, so that we can then come back to the present day again with all of your interesting and great responses to those first couple of questions. If Mark would slide down for us, last week I talked about 3 foundings, right? And so I kind of want to go back to that idea as a way to talk about federalism. So our first founding was the Declaration of Independence and the creation of the Articles of Confederation, right? And we talked about that context being a time when people felt really close to their state governments. And so in the Articles, we get this model where, as it says here in Article 2 of the Articles of Confederation, each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right, which is not by this confederation, expressly delegated to the United States, right, in Congress assembled. So we've got states retaining almost everything, except those things that they're going to expressly delegate. And they're going to not expressly delegate very much at all in this particular document, in this particular form of government, right? States also, they use this phrase, firm league of friendship with each other, and they lay out some of the reasons why they're getting together, but the biggest of which being common defense and to assist each other against attacks made upon them, right? So they are bonding together for this reason of defense, and then only giving the federal government power that is expressly delegated to it. Okay, so that's our first founding. So let's scroll down to the second founding, right? And we've got the preamble. So we've got the second founding is the Constitution, right? 1787, with the Constitutional Convention in Philadelphia. And now we have, not as we had with the Articles of Confederation, we the states, right? State sovereignty. Now we have we the people, expanding the power of government and a government that represents the people themselves and not just the states. Popular sovereignty, not state sovereignty. And so if you remember from Tim's presentation in week 2, right, the New Jersey plans and Virginia plans had different views about state sovereignty and popular sovereignty at the Philadelphia Convention. New Jersey would have kept pretty much the Articles. That's what they envisioned and wanted. And Madison's Virginia plan really wanted popular sovereignty, a national system in which people were represented directly. So when they end up with a compromise, really that's probably more Virginia plan than New Jersey plan, but doesn't lose some of the ideas of state sovereignty or state power, we get this idea of 2 levels of government with power distributed. Okay, and so now we're going to look at some different sections of the Constitution that kind of break down national power and state power. So I've given you just some sections, not the whole Article 1, Section 8, but just some sections of Article 1, Section 8, and specifically chosen these because they are the areas that are often the most referenced in expanding federal power. So the taxation power in the first part there, then we've got the commerce power, which we'll talk about a little bit in more detail later tonight about how that's been used. And then finally, that last bit there, the necessary and proper clause. So it's important to understand that the necessary and proper clause, although a clause that broadens things, is not untethered, not an untethered clause, right? It's to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, the previous ones in Article 1, Section 8, right? And all other powers vested by this Constitution in the government of the United States as a whole. And so famously in the McCulloch decision, which is the bank case from the early 1800s, McCulloch v. Maryland, Marshall said the following about the necessary and proper clause. He said, let the end be legitimate. Okay, if the end, the goal of the use of it is legitimate, let it be within the scope of the Constitution. And if that's the case, if the end is legitimate and it's within the scope of the Constitution, it's right, one of those previous powers in Article 1, Section 8, then all means which are appropriate, which are plainly adapted to that end, and which are not prohibited, but consistent with the letter and spirit of the Constitution, are constitutional. So the necessary and proper clause is about means, right? It's about the laws or the means for carrying into effect the foregoing powers, right? And that's important to understand, because I feel like sometimes when people look at the Constitution and look at Article 1, Section 8, they're sort of like, well, there's the necessary and proper clause, and that means Congress can do anything. And that's not what it's saying. That's not really how it's been interpreted either. So let's scroll down to the next part of the Constitution here. Article 1, Section 10. Here is where the states were limited, right? So again, we're talking about the second founding. We're talking about a desire to get the country in line, right? And so in doing so, they decide we got to limit the states because we're afraid that they're going to be acting against the spirit of the Union. Madison famously wrote in his Vices of the Political System when he was writing about the Confederation, saying like, you know, the Confederation is a destructive union. It's destroying itself from within based on how it's been created. And part of the problem is that states are acting against the interests of the Union. So we're going to stop them from doing that, right? We're going to tell states that you can't enter into treaties with each other, mini confederations, right? You can't, without the consent of Congress, lay taxes on imports or exports, right? And actually, if you do that, then the money you collect is going to be for the U.S. government, not for you. And you also can't, engage in war unless you're being attacked, right? You can't engage in foreign relations. That's something that the national government is going to do. So they're clearly answering some of the problems of the Articles of Confederation here with Article 1, Section 10. All right, so we've got Article 1, Section 8. This is what Congress can do. We've got Article 1, Section 10. Here's what states can't do. Let's move on. Another really important federalism clause or section of the Constitution is Article 6.
Shayne, can I jump in just for a second?
Yeah, go for it, Tim.
If you, Mark, scroll back up to the prohibitions on states.
Yeah.
You'll I can't help but get all jiggy about the ratification period here. There's prohibitions that states can't do certain things, but many of the people during the founding period, when they saw all this new territory in the West, these are not states. And so many of them were afraid that those territories could do alliances and could do confederations because they weren't states. And so when they set up the Northwest Ordinance, they had pretty low, what I mean by that, low population standards for territories to become states. Now, you can look at that and say, well, isn't that generous? But there's also, we need to control these territories because they're not restricted in this potential constitution. So, and if you know anything about the ratification in the era in the 1780s, the West was a troublesome place, and there was fear that the people in the West as territories could do many of those things that are prohibited, as Shayne has pointed out in Article 1, Section 10. So the low standard of becoming a state is not is directly related to that fear of those territories doing those things.
Thanks, Tim. I did not realize that. That's great. All right. So let's move on to Article 6. So this is the supremacy clause, right? So laying out that the Constitution, the laws of the United States, notice made in pursuance thereof, those that are constitutional, treaties that are made under the authority of the U.S. are the supreme law of the land. And then the last part is who's bound by that? Well, the judges in every state are bound by the Constitution. anything in the Constitution of the laws of this, the Constitution of the state, or the laws of the state, to the contrary notwithstanding. This is really important, right? This is saying that the national constitution is supreme to the state constitutions. It's the national constitution and the federal laws are supreme to state laws. And even you state judges, you have to abide by this. So again, kind of going back to the founding period, if you read in the anti-federalist documents, they're constantly talking about how their courts are going to be usurped, right? Their courts are going to become meaningless. Their judges are going to become meaningless. I think they were thinking about the supremacy clause at that time as part of that concern and that fear. Okay, so that's in the body of the Constitution. We've got one more part that, one more section I think that's part of this second founding, and that's going to be the 10th Amendment, right? So when you hear people talking about states' rights and state power, pretty much anywhere in popular discourse, right, they're going to talk about the 10th Amendment. And the 10th Amendment, which says that power is not delegated to the US by the Constitution, nor prohibited to it by the state. So not delegated in Article 1, Section 8, right, nor prohibited to it in Article 1, Section 10. Those powers are reserved to the states or to the people. And so, you know, when you look for how do states get authority, a lot of people point to the 10th Amendment. They say, well, the states have general police powers, right? Police powers are the power to look out for the health, safety, and welfare of the citizens of that state, and the morals, and make laws that will do that, right? And the 10th Amendment, though, is definitely saying that, but it's also restating, I think, what people would have thought at the time of the Constitution, and even many Federalists would have agreed that states had not given up their general police powers when the Constitution was ratified, right? They'd given up some authority, but they hadn't really given up those general police powers. So the 10th Amendment, I think, was thought of as sort of stating what people understood about what their states could do, that states would have these general police powers to make laws about health, safety, welfare, and morals of their citizens, their general criminal laws, their creation of municipal governments, right? Whatever the local people needed, creation of local courts, all of those things that they would do as states. Okay, so that's our second founding, right? We've got first founding was the Articles of Confederation. Second founding is the Constitution and the Bill of Rights. Third founding is what I talked about last week, right? And that's going to be the 13th, 14th, and 15th Amendments in the aftermath of the Civil War. So, Mark, if you scroll up for us one more time here, or scroll down, I'm sorry, to the 14th Amendment. Thank you. Now we've got this no state shall clause, which is going to further limit what states can do, right? States are being told that the national government is defining citizenship, and here's the definition, and you states have to abide by our national definition of citizenship. Furthermore, states are being told you cannot make or enforce certain kinds of laws. So this is like another Article 1, Section 10 piece. You can't abridge privileges and immunities of citizens. You can't deprive people of life, liberty, or property without due process of law, and you can't deny equal protection of the laws. Okay, so this is adding to Article 1, Section 10 there, and then if you look at Section 5, I really think they're adding to Article 1, Section 8, right? They're giving Congress another power. Congress now may enforce by appropriate legislation the provisions of this article. Now, as I think I talked about a little bit last week, Congress has not used its 14th Amendment, Section 5 powers very much, but there's an argument to be made that this potentially could be expanding the power of Congress greatly to enforce these provisions of the 14th Amendment, okay? So, for instance, a little bit later, you'll be looking at excerpts from the famous case Heart of Atlanta Motel, which upheld the Civil Rights Act of 1964 under the Commerce Clause, right? But it seems like perhaps if it hadn't been shut down by previous Supreme Court decisions, that 14th Amendment Section 5 may have been a place to locate some of those powers. Okay, so we've talked about the first founding, second founding, and third founding. I want to switch gears a little bit and move over to talking about some cases. Let's see, Mark, why don't we close up the slideshow for a second, and I have a few things to say before we move on to the next document I want to. Oh, we can leave that up. That's fine. So the debates about what level of government is responsible, right, and where the bounds of federal power are has been going on for a long time, right? It's been going on since, through these documents, but also, the debates over the national bank and whether or not that was a legitimate exercise of federal power during the Washington administration is one of these earliest examples of who has the power to do what. Also, this has been an important part of the role of the judiciary, right? To tease out these pieces, these parts of the Constitution and figure out exactly what they mean and to figure out exactly where power lies. So I want us to dig in a little bit more to the court's role in this by taking a look at some of these Commerce Clause cases. So I'm going to work us through excerpts A and B on this particular sheet here. And then we're going to be shifting over into breakout session for y'all to look at some of the other cases on this handout in a little bit more depth. So looks like Mark posted the link. If people want to click on that and look at it on their computers, but we've also got it here on the screen. So the first case that we're going to look at is Gibbons v. Ogburn. Gibbons v. Ogden. That's a typo on my part. I'm sorry about that. I got to fix that. It's Ogden, not Ogburn, from 1824. This is about a conflict between a state license to operate steamboat service between New York City and New Jersey and a federal license for the same service. So this is Chief Justice Marshall and his court presented with this question of, is navigation across rivers, is transportation commerce? So it's therefore the ability of the federal government to regulate it. And if we've got this issue of a state license or a state monopoly granted by a license or a federal one, which one wins out, state or federal? So Marshall said the following in this decision. He said, few things were better known than the immediate causes to which led to the adoption of the present Constitution, that the prevailing motive was to regulate commerce, to rescue it from the embarrassing and destructive consequences resulting from the legislation of so many different states and place it under the protection of a uniform law. So, Marshall is saying, look, we wrote this Constitution to have a uniform law. We can't have these states making their own laws regarding commerce because the whole point of writing the Constitution was to deal with this commerce issue and the fact that the states had different laws. He then goes on to say, we do not find in the history of the formation and the adoption of the Constitution that any man speaks of a general concurrent power in the regulation of foreign and domestic trade as still residing in the states. States don't have control over foreign and domestic trade between states or trade with foreign nations. Okay, that's not what the Constitution was about doing. And then finally, so there we get the fact that the federal government has the right to regulate this federal license is going to win out. And then he goes on to say, the subject to be regulated is commerce. It becomes necessary to settle the meaning of the word. Sorry for the other typo there. Commerce undoubtedly is traffic, but it is something more. It is intercourse. The mind can scarcely conceive a system of regulating commerce between nations, which shall exclude all laws concerning navigation. Like I can't even fathom that you could have meant commerce and not mean transportation or navigation across this river. So duh, right? Marshall says commerce includes navigation. All right, so we've got an expansion now, right? An expansion of commerce power and an expansion of federal authority, right? That's an early one, okay, from the early Marshall Court. Mark, scroll down for a little bit for us. And the next excerpt I want us to look at is Wickard v. Filburn. So this was another important shift in the history of the court and their views about the Commerce Clause and their views about federal power, right? This is a case stemming from the New Deal and stemming from parts of the Agricultural Adjustment Act, which controlled how much wheat could be produced by farmers, even if that wheat wasn't going to leave the state. So the question becomes, if something is solely within a state, why can the federal government regulate it, okay? And so the court in a 7-2 decision says the following. Even if appellee's activities be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce. And this is irrespective of whether such effect is what might at some earlier time have been defined as direct or indirect. So we don't care if it previously was only indirect or direct. What we're saying now, right, in this new precedent, is that if it exerts a substantial effect on commerce, then it can be regulated by the federal government. This is an important precedent because this will then carry through for really a long time as the idea of what the extent of federal power and what commerce, what the Commerce Clause meant. So I've been talking for a while now, and so I'm going to ask us to break into some breakout groups. And when we do that, I want to give you a couple instructions, okay? So if you noticed at the top of this page, there were some questions in red. And so when you go into your breakout groups, I want you to look at the rest of the cases on this sheet. So create cases C, D, and E. There's 3 more on here. And for each of them, take a look and talk about those questions. Talk about what is the court saying is commerce, right? And then do you agree or disagree? What do you think? And having read all these definitions of what the Commerce Clause means, right, where do you stand? How do you view the appropriate role of the federal government and what counts within their Commerce Clause authority, okay? Once you've done that, I'm going to ask you to then, on the Learn site, there's a link to the OAA page for the case US v. Morrison from the year 2000. And that's a case regarding the Congress's Violence Against Women Act. And I'm going to ask you to sort of, given what you all think the Commerce Clause means, then, right, how would you apply it in Morrison? Do you agree with what the court decided in this 5-4 decision, or would you have sided with the dissent? And to complicate things further, there's a way we can also think about whether or not, if Commerce Clause doesn't work in Morrison, does the 14th Amendment work? And is that Section 5 of the 14th Amendment that we looked at a little while ago another place that you might go for authority in Morrison? Okay, so that's a lot of stuff. Does anybody have any questions before we go into breakout?
There was a good question raised, and I forget, Tim, who raised that? Was that Joan that raised that in our group?
Yeah, in the context of Heart of Atlanta, I just simply posed, what if I owned a diner in the middle of nowhere county, Georgia, and nobody ever came into my diner from anywhere else in the country? I just posed the question, would Congress have the authority to regulate my business? And Joan, your question was?
Could unmute Joan?
I'm unmuted, okay.
Yeah.
For me, the issue was if you're open to the public, then you have to have your business open to the public. And it doesn't matter how isolated you are. That's what struck me. I mean, if you advertise as being open to the public, then you have to serve everyone in the public.
If I could jump in, we talked about the same thing in Group 3, or a similar issue in Group 3, but we found it interesting, Timmy and Mark, that here we have, the basic issue here is treating people fairly, right? If you're a public business, that you treat people fairly and you don't discriminate against people. And yet we can't go to the Equal Protection Clause for relief in the Constitution, because the Equal Protection Clause regulates government. And so we have to get to that important principle. We would say that that's consistent with American principles and core values. And so we have to use the Commerce Clause, and specifically an act of Congress, the Civil Rights Act of 1964, to make that, to kind of nationalize that kind of simple fairness. Is that do you guys agree that that's kind of what this case says?
Mm-hmm.
Yeah, I also, just putting this in chat, but I also think, the court, if they really wanted to go to the Equal Protection Clause, there wasn't, if you look at the civil rights cases from 1883 and you look at Justice Harlan's dissent, he basically says the earlier version of the 1964 Civil Rights Act, the 1866 Civil Rights Act and the 1876 Civil Rights Act were fine. Those are fine laws passed under Section 5 of the 14th Amendment. And to resurrect that dissent and say, this is a legitimate action of Congress to make sure there's equal protection, and there's equal rights for everyone, and we don't have to, the state action doctrine, that idea that it has to be the state that's doing the discriminating, comes from the way that those civil rights cases went down, with majority winning. If the dissent if it had gone the other way, we'd be in a very different place. That's not what the court has done. And in Heart of Atlanta, they were happy to go along with commerce. But I think that if we want to imagine a more expansive 14th Amendment, we can go back to those civil rights cases from 1883.
Great point.
Mhm.
Okay.
Sorry.
So Shayne, do you want to talk about your group at all?
I think Ryan's going to talk a little bit.
Oh, Ryan. Okay. Ryan, you can just unmute yourself.
Okie doke. So yeah, we talked pretty extensively about Heart of Atlanta and how the court stayed with Wickard, and obviously was looking at it with a pretty broad interpretation of saying it's congressional action. We're not going to tell you where or what to do, but it's appropriate for Congress to take this action. And then when you get to Lopez, obviously, they're looking at it as a criminal statute and saying, this isn't commerce. You've definitely overstepped. But then when you get to the Affordable Care Act case, then, we were saying how Roberts is going to find a way. He isn't going to go with the individual mandate being commerce, but it might fit under the taxation clause. And so, that one, it's interesting to see the change in the court perspective. And again, maybe even just the way that the court interprets it, from the Warren court to the Rehnquist court to the Roberts court, how they're going to use those differing philosophies in, what clauses or what action is appropriate.
All right, great. Any other comments about that? Okay. Tom, do you want to share your
Just
group?
one last thing. We didn't talk about this in our group, but it did occur to me as we were talking about all of these issues. And I'd be interested to hear from not only the presenters, but from our participants as well, that while we think about federal power and state power and how that's shifted over time, one thing that we often don't teach about that is also important to think about is what things are best left to the people themselves to work out, right? And I live in Kansas. There are a lot of people that think that government, whether it's state or national or some combination, has become too invasive in our lives, and that there are lots of problems that would be better resolved left to the people themselves in civil society, or acting as individuals or whatever. And I think that that's another aspect of how we divide power that is worth considering. What kinds of issues, what kinds of problems, just because we can identify a problem, does it necessarily mean that it's the government's responsibility, whether it's state or national, to resolve? As an example, let's just take the individual mandate. Couldn't it be argued that in a free society, that a young person that's relatively, I'm playing devil's advocate here a little bit, a young person that's relatively healthy could make the decision to roll the dice? I'm not going to buy insurance, and I'm not going. And it's unconstitutional for you to make me buy insurance, because I am a free person and I get to decide where I spend my resources. Now, you don't have to agree with me. I'm a social studies teacher. I love people disagreeing with me. And so, but I don't think that that's an unreasonable argument, to be honest with you. And I don't even think it's unreasonable, and this is really going to tick a lot of you off. I don't necessarily think that people that are against requiring you to wear helmets on a motorcycle are necessarily wrong. I know the counter arguments to all these things, and I'm ready to argue with you, but we probably don't have time. Or smoking laws, right? And that one I'll certainly win on. Smoking laws in private places. I promise you, if you wanted to debate me, we can do it sometime, and I will take you on that. So,
hey Tommy, Tommy, isn't it ironic that the person who doesn't want to buy health insurance is probably the same guy who doesn't want to wear a helmet on his motorcycle, and therefore the society has to pick up literally the pieces.
Well, okay, Bobby, you want to argue with me? I'm ready. I'm ready for you. You're probably.
I'm just pointing out, it's like that's do you have an obligation to promote the common good to have some kind of insurance?
You can take that argument to an extreme, right?
Yeah, sure.
Eating sugar or carbohydrates is bad for society. It's bad for you individually, and it's also bad for society.
Should the government regulate that?
So should the government put, a huge tax on sugar and quit carbs? I mean, it's good for you. We know what's good for you. That's not really what this country's about. This country's about maximizing freedom and hopefully having an education system that helps people make good decisions by themselves without having the government to intervene. The smoking laws in public places, I'm fine with, like a library or a school or whatever, anything that's public or run by the government. But what about private places? A bar. If you don't want to smoke or endure smoking, don't go to somebody else's bar. And people say, well, it's the secondhand smoke and it's a health and safety issue for those poor workers in the smoking establishment. And I say, boo-hoo. There's a whole bunch of jobs that have way more risks. What about coal miners, for God's sake? They have a
So
few.
Your point is, Tommy, is what level of government, if any, should make these decisions?
There's some things that probably we've gone too far with, and nobody ever points that out, right? Nobody says, geez, the government shouldn't be involved in that at all. But I guess a few people do. But usually it's just looking to the government to if we notice a problem, we look to the government to resolve it. I mean, we could ban alcohol. Alcohol's not good for you. I mean, I was in Chicago on St. Patty's Day, and alcohol is not good for you. All right, I'm still a little red in the face from my Chicago trip, but we live in a free country that allows us to make good choices and also stupid choices.
Gotcha.
I can jump back to just real quickly to Unit 1, which I missed. I apologize, but I think it was Aristotle said you can tell the health of a community or a society by how few laws it has, right? A healthy society has very few laws, but a society that has many laws is not what you would call a healthy society because you have to control human behavior. So I'm not sure what, just to dovetail off what Tommy was ranting about there, but that, we have a lot of laws. I wonder what that says about our society, whether it be smoking or carbs or sugar, or please let's not talk about banning alcohol. That's just, that's a fool's errand. We tried that. So.
Been there, done that. Shayne, you want to have some concluding remarks here?
Sure. I just want us to briefly look. I have written some discussion questions. Mark, if you would just mind pulling those up for the group.
Sure. Yeah.
Just some things for you to think about. We didn't have time. I saw in some of the comments that got pulled up at the end, some questions about obviously the marijuana issue, which is a current debate about, we have these federal laws against marijuana. The states are violating them. What should happen? How does that get resolved? So thinking about also what are the benefits of retaining areas of state sovereignty, of state power, the idea of laboratories of democracy, the idea that, states come up with innovative policies that then might be adopted by other states or by the national government. So thinking about some of the benefits of allowing states a lot of flexibility and freedom. I mean, it seems actually with the marijuana issue, part of what's happened is it's building, and we'll see if we ultimately get federal legalization because of the way it's built first within the states and these governments that are closer to the people, right? Another taking away some of that federal regulation, going back to what Tommy was talking about, and thinking about the potential problems or disadvantages. And then I think we're at question number 3, because I think it's also really relevant, because in times when you'll notice you keep seeing this shift, right? People who disagreed with the Obama administration were constantly looking to states as models of the kind of government they wanted. When President Trump came into office, people who were frustrated with the Trump administration looked to states and said, oh, state governments, solve my problems, California with environmental regulation. So this question of whether or not anyone's really a principled supporter of state power, or do we tend to turn to this idea of states' rights when we don't like the direction of federal policy? Then we become, huge states' rights people. And then as soon as federal policy gets back in line with what we agree with, we're back supporting federal power. So I think that's a really interesting question. And then finally, we already really talked about for a fair amount, I think, in our breakout sessions. But I just wanted to pose those other questions for us to think about as we think about this issue. So that is all I had. I want to thank you guys again tonight.
Hello, everybody. My name is Chris Cavanaugh. I'm a teacher in Bismarck, North Dakota, Bismarck High School. As Mark alluded to, I've been teaching for a couple of years now, and I've taught for a long period of time in central Indiana at Plainfield High School. And I've been using the We the People curriculum for many, many years. And I've known Mr. Lemming, oh my gosh, a few years, and Mr. Vance also when he was back in Indiana, and as well as Tim for a number of years. So I hope I can carry us through here, because these guys have set pretty high bars to follow so far. We are doing executive power and the growth of executive power. And I thought the best way to do that is to go back to the beginning. What was executive power as it was debated at the convention, and what came out of the convention, and kind of get to where we are now, and then maybe allow you guys in a breakout room coming up to think about the traits. These are the traits that the framers were thinking about. What are the traits you guys would be thinking about in terms of our chief executive? So I don't have an exercise set up for this, but I always like to do this with my students when I start this discussion with executive power. And I said, draw a pie chart on the board, draw 3 equal pieces of pie. I don't believe that the framers intended that, and Tim can jump in anytime and correct me, but I think they intended legislative supremacy. But we teach the 3 co-equal branches, so we'll go with the 3 co-equal branches of government with the legislative, executive, and judicial branches. And then if they were designed to be co-equal branches, I always have a student come up to redraw the lines. What do you think today, right? Here we are in 2019. Whose piece of the pie is bigger? Is it the legislative branch? Is it the executive branch? Is it the judicial branch? And invariably, students will make the executive piece of the pie way bigger, and they will reduce the legislative and the judicial somewhat. More so, they take the power away from the judicial branch. And then I ask this question: if this is the case, has this been an abdication of power by the legislative branch, or has it been a usurpation by the executive branch of legislative power? So, has the legislature willingly just said, here, Mr. President, take it, we're not using it? Or has the president just come in and taken it, and Congress has done nothing to respond to that? So that is an interesting question to debate. And I think the answer to that is abdication or usurpation, and yes is the answer. That's the answer. I think it's a little of both. But anyway, and anytime you guys have a question, please throw it up on the chat. we'll let one of these scholars in waiting and residence here to pick it up, and we can always kick that around. So I'm always open to questions. So we'll start with this first one, the Philadelphia Convention, no clear theory of executive power. If you would go down to the next one for me, please, Mark. And of course, yeah, we got to start with the Virginia plan. So it's interesting. I mean, Shayne started her presentation going back to look at the plans, and we're looking at the plans here as well, because what kind of executive should we have? Is it, we're going to have an executive. Is it going to be single? Is it plural? How are we going to determine him? Is he, in the Virginia plan, it's going to be elected by the legislature. A 7-year term, not eligible for reelection. And then I think Tim had mentioned the Council of Revision, which was judges along with members of this executive branch to determine the constitutionality of laws before they went into place. I believe they're called advisory opinions. And we don't have that, but today a modern equivalent may be considered the Office of Legal Counsel in the White House, White House Office of Legal Counsel is part of the White House, and they're available for the president to. The joke or the argument is it used to be the president would want to do something, and he would ask the people in the Office of Legal Counsel, "Is this constitutional?" And now the joke is the president wants to do something and he says, "How is this constitutional?" So it's become their job to maybe find out, making that argument of how something is constitutional. So that's the Virginia plan. Some of it, most of it, what Madison wanted sounds almost like a parliamentary system. But if you scroll down to the the New Jersey plan, thank you, sir. Again, a plural executive. 2, 3, should we have an executive from the northern states and the middle states and the southern states? Hamilton definitely thought no. He wrote about that in the Federalist Papers and how that would be a bad thing. I think he compared it to the Roman triumvirate and how 2 would invariably turn against 1. Elected by the legislature, seems similar. Ineligible for a second term, and removal at request of Congress on application of the majority of state governors. So you see the New Jersey plan, as we're familiar with by now, certainly kind of giving power to the states. Can you imagine today if the state governors had the ability to remove the president? Holy cow, that's a can of worms. If you go ahead and scroll down then, please, Mark. Thank you. And the Hamilton plan. I think this was mentioned before, and Tim, again, I rely on your knowledge here, but whether the Hamilton plan was, made to make the Virginia plan look better, Hamilton was serious. Hamilton gets a lot of, credit for his line about energy in the executive. And so we'll talk about that. But again, Hamilton's plan, one person. Elected by electors from districts. That sounds familiar. Life tenure, but impeachable. President for life. And he would have the absolute veto, not a qualified veto, and have direction of war when authorized or begun. And oh my gosh, this is almost a reversal of the New Jersey plan to appoint state governors. That would be, wow. And you can see how a lot of people were very, very upset with it. Not the Hamilton plan, but bullet point number 2, we end up with the Electoral College, which we might get to hopefully into a discussion. If you would go ahead and scroll down, please. Thank you. These are some thoughts here from some of the framers on what they believed characteristics of a good executive. This is our boy, James Wilson. James Wilson is one of the few guys to sign the Declaration of Independence and the Constitution from Pennsylvania, a lawyer and a judge, very successful there, but got crossways with some bad real estate and ended up in jail for a length of time. But his law lectures were very, very influential. And you can see energy, efficiency, and responsibility. Those traits that, are probably good to a degree today, too. If you go ahead and scroll down, please. Thank you. Roger Sherman from Connecticut. Roger was involved in the Great Compromise, or the Connecticut Compromise. If you're a fan of 1776, the musical, he was simply a cobbler from Connecticut. Carry out the will of the legislative branch. Now think about that for a second. This is the role of the president. is to simply carry out the will of the legislative branch. And we can talk about the take care clause, because that will be a huge part of the Article 2, that the president take care that the laws be faithfully executed. So in essence, if you think about the take care clause, that really is what Roger Sherman is talking about.
Chris, if I could pipe in just a second.
Please.
I think to your point about Roger Sherman's the take care clause to carry out the will of the legislature, I think it's underappreciated the amount of influence how the articles functioned. There were so many of these committee chairmen that did executive type jobs during the Articles of Confederation, and they literally were at, if a committee of Congress told them to do something, they carried out the will of the legislature. So much of if a founder saw the presidency as simply to do the will of the legislature, it's not just that they're saying, let's be parliamentary like England. They're saying, let's continue that tradition of the legislature pretty much having people do executive function as almost an errand boy. So that's a legacy not only from Britain, but it's also from the Articles era when committees had these chairmen that did their jobs.
Well, that's interesting. I mean, I maybe now would be a good time to point out, and I don't know if you have a copy of the Constitution in front of you. I just happen to have my Carl Malden copy. I don't leave home without it. And then you have to be of a certain age to appreciate that line. Sorry, Shayne. But if you look at the beginning of Article 1, the legislative branch, and I always have my students read this: all legislative powers herein granted shall be vested in the Congress. And that line, and the wording herein granted. And if you jump to Article 2, it says the executive power shall be vested in a president of the United States. So you've got legislative power that's herein granted, in this document, the Constitution, but we're also having executive, and, the debate becomes, I don't mean to fast forward here, but, what does it mean to be an executive, right? What does that mean to execute or carry out the laws? So that wording is interesting in itself. Mark, if you would go ahead and scroll down for me, please. Thank you. And one of my favorite guys, Gouverneur Morse, or as Peg Leg, as I like to call him, he's quite the ladies' man, allegedly. So I'll leave it at that. And look at this: protect the people from the legislative branch. Whoa, that's a really kind of out there thing. It's almost like Madison will write about later in one of his papers about interposition, right? The idea of putting yourself between the government to protect the citizens from an over-abusive legislative branch. So you have some different traits there. Gouverneur Morse was also the guy that wrote the preamble to the Constitution, the Committee on Style. And I wanted to go back for a second and go back to something Shayne was talking about, because if you look at the beginning of the preamble, it says, "We the people." And to talk about our debate about federalism, to regress for a second, Morse had originally written "We the states," and had Morse left it at "We the states," that really would have thrown a monkey wrench into our debate about federalism. Anyway, he did not, so the what if game doesn't work there. Could you go ahead and scroll down for me again, please, Mark? All right, what we want from an executive effects, right? How many do we have? How many do we want? How's he to be selected? How long is he going to be in office? What are exactly his powers and what are his limitations? And this is, if you look at the convention, and again, Tim, please jump in, but these are the things they debated and went back and forth. But as they're designing Article 2, there was no secret who the first president was going to be. Everybody knew it was going to be Washington, right? I mean, I think John Kaminsky, who Tim works with in Wisconsin, would call him the indispensable founder and framer. Without Washington, none of this works. And Washington's virtue, by the way. And but the question becomes, who after Washington? Right? After Washington is kind of a game on kind of thing. So who after Washington? So we're writing this knowing that Washington is going to be the man, but after Washington, who is it going to be? And as you look historically, you know, immediately parties form and groups divide up, and you know, you've got the Jeffersonian Republicans and the Hamiltonians and the Federalists, and it becomes politics as we know it. So these are some interesting questions. Mark, if you would scroll down, please. Thank you. Here are the compromises we reached. The term in office. What did we get? Well, you got a 4-year term, and you can be reelected as often as possible until we get to FDR. And after FDR, we get an amendment that will limit the president's time in office to two terms. The irony is the Republicans will push that through, and Eisenhower, who was a very popular president, probably could have had a 3rd term. A little trivia question for you. How long can a person be president? Total number of years. You want to throw a couple guesses up there, and if you know, you can throw it up there on the chat if you want. How many total years can a person be president? Look at all these people know their stuff. Are you kidding me? Oh my gosh, we got a bunch of experts. 10 years it is. Yes, you can be president for 10 years. Because if you fulfill as vice president, if you get 2 years to fulfill a role, then you can be elected twice on your own. So 10 years total. Re-eligibility, originally, of course, you can be reelected as often. Selection becomes the issue, right? Qualified veto power. So obviously President Trump just used his first veto of his presidency, but with a 2/3 supermajority, obviously Congress can override that. The selection became an issue. One of my favorite quotes is from George Mason, who was at the convention but did not sign the Constitution for want of a Bill of Rights. But he said, trusting the people to elect the president was like trusting a blind man to a trial of colors. Ouch. These guys did not have a lot of faith in the ability of people to make that determination, plus communications being what it was, and technology being what it was not really possible to get that done. So we end up with what we know today as the Electoral College, a term not mentioned in the Constitution. Of course, we know that that's going to be amended by the 12th Amendment because with the election of 1800, there is a tie, and we know that that kind of threw a monkey wrench into things and actually leads to Hamilton getting shot by Aaron Burr and all kinds of craziness. Go ahead and scroll down for me, please. Thank you. Here are the Article 2 executive powers.
Chris, Burr would have shot Hamilton regardless of the election of 1800.
Thank you, sir. Yeah. And he wouldn't have been the rock star that he is today. Commander-in-Chief of the Army and Navy, when called into the actual service of the United States. That last part is important of this Article 2. That's Article 2, Section 2, Commander-in-Chief of the Army and Navy, when called into the actual service of the United States. Because who does the calling? Congress does the calling, right? Article 1, Section 8, Paragraph 11, or Clause 11, Congress has the power to declare war. And they did debate about that word, declare, wage, who has this power. Once war is declared, how can the president carry things, to what extent does his power extend? To side story here, Madison and Hamilton will engage in a series of letters back and forth during the Washington administration when Washington tried to unilaterally get us out of a treaty, do it on his own. Hamilton said he should be able to do it. So if you're familiar with the Pacificus Helvidius letters, Hamilton writing as Pacificus and Madison writing as Helvidius, Madison's going to argue that Congress has the power to commence, conduct, and conclude war. Now think about that. Here's a guy that, was somewhat involved in writing of the Constitution. I mean, he does get that moniker, the father of the Constitution, a title he didn't really care for, but he's arguing that Congress has the power to commence, to conduct, and conclude war. Obviously, the war declaration power in Article 1, Section 8, the ability to appropriate money for the war, and the confirmation of treaties that would conclude war. So that's an interesting argument these guys were having. And a little side note I like to use with my students, and I think that the pertains to us even to this day. If two guys that wrote the darn thing, that were in favor of the darn thing, the Constitution that is, are going to argue about its interpretation, they were there, they wrote it, and they're arguing about its interpretation, how are we not supposed to? Seriously, how are we not supposed to argue about interpreting the Constitution if the two of the guys that wrote it and were in favor are going to argue about how to implement it? So it's okay to argue about it. Grant reprieves and pardons for offenses against the U.S., except for in cases of impeachment, and that was hotly debated. People were not keen on the pardon power, but that goes back to royal prerogative, I believe, and Tim again will jump in and correct me even if I'm right. Make treaties with the advice and consent of the Senate, and nominate and appoint ambassadors, public ministers, consuls, judges with the advice and consent of the Senate. And if you're familiar with Judge Garland's nomination by Barack Obama, as we know, the Senate is not compelled to give advice and consent. That's their authority for the person to become on the court or to a federal judgeship, but the Senate is not compelled to do that. So you can see that how these powers are somewhat woven together. Could you scroll down, please, Mark? Article 1, executive power, right? So you do see some of the executive in Article 1. Again, a veto with a statement of objections and qualified. And some things that I don't believe we'll see on the slide, but might be a good place to put in here, is that we have executive orders and signing statements. Executive orders have been around since Washington, and they have been ruled constitutional. They are part of the idea of the take care clause, that the president has to take care of the laws be faithfully executed, and at times he may have to issue an executive order, and they are binding as law until they're changed by Congress or changed by a future president. Okay. The signing statement is a little newer, I say newish, but they've been around for a while. Traditionally, the signing statement is involved when the president is signing a bill into law, authorizing it to be law. Traditionally, they were historical markers, if you would. The president explaining the importance, perhaps, of a piece of legislation. It wasn't until a more modern presidency, and President George W. Bush, I can think of off the top of my head, will issue a lot of signing statements, and the idea that he will reserve the right to perhaps enforce the law as he sees fit. And I think one of the famous ones was with the Detainee Treatment Act, when during the War on Terror, we found out about, depending on your point of view, either torture or enhanced interrogation techniques. And Senator McCain, if you will, remember that his time in the Hanoi Hilton was very opposed to these harsh techniques, and was convinced President Bush to sign this legislation. But later, President Bush will, in his signing statement, basically say that he will reserve the right to enforce this law as he sees fit. So those are a couple of things outside of that we don't necessarily in the Constitution that have absolutely grown executive power. I mean, there are some very, very famous executive orders. Probably one of the most famous is the Emancipation Proclamation issued by Lincoln to free the slaves in the states in rebellion against the Union. You have Executive Order 9066 by FDR, which will allow for the internment of Americans of Japanese descent. You have Harry Truman in an executive order integrating the U.S. military. Some more current ones, obviously, you have President Obama with his DACA and DAPA executive orders with what we call the Dreamers. And so executive orders have been used extensively, and they are been around since President Washington. Mark, if you would go to the next slide, please. Okay, so we have some powers, and now we have some responsibilities. You have the State of the Union address. For you guys, many of you guys know this, that for the longest time, presidents would write a letter and send it to Congress. And I think it was President Wilson that actually started the process again of going to give the address to the joint session of Congress. And now we have the State of the Union address, which is a huge, huge event where the president obviously will lay out his framework, recap the year or what his framework is for the upcoming year. Recommended Congress measures that shall judge necessary and expedient. If you think about it, we've got a piece of legislation that everybody like to call Obamacare. So I always ask my students, wait a minute, I thought the lawmaking power was with Congress. Why is it called Obamacare? Was he in Congress? And then you have to come back to this, that the president works with Congress in drafting legislation, measures, necessary and expedient. And again, the take care clause to be faithfully executed, and you take the oath. And the oath of office is coming up. We'll see that in a second. So if you would go ahead and scroll through, please. And there it is, right on cue. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. I thought a little qualifier in there, to the best of my ability. So I guess if you get crossways, you can always say, well, it's the best I could. Sorry. So I don't know. So, and of course, what is not in there is what Washington added, which is, so help me God. Right? Washington adds that. So every president after Washington feels compelled to say that. And if you remember when Obama was sworn in, Chief Justice Roberts kind of screwed up because he reads the oath of office and the president, as he's being sworn in, has to repeat it. And Chief Justice Roberts said, so help me God. And Obama said, so help me God. And then some nerd like one of us said, hey, that's not in the Constitution. And so Obama had to go back and do it again in a different ceremony because that wasn't technically the oath of office. So, which actually shows you everything that Washington did set a precedent. Everything he did. Served 2 terms now, right? Until we get to FDR. The things that he did, there was really not a lot of model for. And he said that we were very fortunate to have that man as our first president. I mean, he was a man of flaws, as all of our founders and framers were, but he was also a man of great civic virtue. So he could have been, well, and you'll see some fears coming up here in a few minutes, in a couple seconds here, what these other folks feared. So we were lucky to have Washington and the precedent that he set. If you would scroll for me, please, Mark. That looks familiar, so keep going, please. Concerns about executive power. Pierce Butler from South Carolina. These are just some quotes that, from some of these people that were there and their fear of this executive. All countries, the executive power is in a constant course of increase. Yes, true. Go ahead, please. Our old boy, Gouverneur Morris again. The love of fame is the great spring to noble and illustrious actions. Shut the civil road to glory, and he may be compelled to seek it by the sword. That's foreboding for sure. Go ahead, please, Mark. Edmund Randolph of Virginia. A single executive is a fetus of monarchy. That's a different spelling of the word fetus as we know it, right? And this is Randolph is the guy that presented the Virginia plan, governor of Virginia, who also did not sign the Constitution. So the idea is that he wanted a multiple executive. Sorry about your luck, Ed, you didn't get it. Go ahead and scroll, please. And Charles Pigney of South Carolina. If the president has power over war and peace, the U.S. will have the worst kind of monarchy, an elective one. So this is why this power is with war and peace is definitely with the legislature. Keep going, please. And George Mason also at the convention, I mentioned him earlier, did not sign the document. We're not indeed constituting a British government, but a more dangerous monarchy, an elective one. Do gentlemen mean to pave the way to hereditary monarchy? And Washington had no children of his own, so we dodged that bullet. Thank you. And this is the Philadelphia. Oh my gosh, I can never say it. Tim, how do you say that word?
Philadelphiensis.
Yeah, the president as a military king. Who can deny? And I'm going to assume this cat was an anti-federalist.
Oh yes.
Okay. Was he from Philly?
He was from Pennsylvania.
Okay. Yeah. Who can deny? But the president general will be a king to all intents and purposes, and one of the most dangerous kind too. A king elected to command a standing army. Now, again, think about this. The convention or the revolution was just a decade earlier, and the fight was against a strong central government. The fight was against a king, and now this new document, Madison's new document, is it creating a king? And these guys feared a large standing army to begin with because a large standing army at times gets bored, and who knows what they want to do. And if you have a president at the head of it, well, that's just too dangerous to contemplate for some of these guys. And it is Wilson, James Wilson, at the Pennsylvania Ratifying Convention that tries to assuage people. And he says that the Constitution is designed so that no single man can take us to war. And if you would ask people this today, right, if you would ask the average person on the street, does the president have the war-making power? And many people, I'm afraid, would say yes today. And that's, that's just wrong. The president doesn't. We're going to get into that here in a few minutes, I think. If you would scroll down for me, please, Mark. So what are the president's powers? Constitutional white space. We talked about this before. I always like to call it, and I'm stealing this from Sue Leeson, who is the author, one of the co-authors of the We the People textbook, Big C constitutionalism and small c constitutionalism. Big C constitutionalism is simple. You got to be 35 to be president, at least 35, right? And a natural born citizen. And you got to live here for at least 14 years. Is that debatable? No, it's not debatable. It's big C constitutionalism, right? Small c constitutionalism is the space between the black letter law, right? It says Congress is going to create federal courts. The Constitution says that. Well, where are they going to put them? I don't know. How many are they going to make? I don't know. How many judges will be on them? I don't know. So that will be figured out as we go along. That's that constitutional white space. And for the president, this is what we just talked about, signing statements, right? Since Monroe, we've been seeing been used a dramatic increase since President Reagan. There's that term unitary executive that we'll talk about here towards the last slide. The idea that the president may not need Congress as much as people think he does. You scroll down, please, Mark. And there's the unitary theory of the president. During war, president cannot be bound by law. Reasons, he's commander-in-chief. And this notion of this inherent power of the president, the idea that there's power built in. President George H.W. Bush, when he went to war against Saddam Hussein the first time, he went to Congress and asked for a resolution. But he privately said, I don't need some old goat in Congress to tell me I have the power to do this. So this concept of this unitary executive, that the president can act unilaterally without Congress. And this goes back to Pacificus and Helvidius. This goes back to Madison and Hamilton arguing about how much power does the president have without Congress. And the inherent power of the president will also come up in this Youngstown Sheet and Tube case, Youngstown Sheet and Tube versus Sawyer under President Truman, when he tries to nationalize the steel mills during the Korean War. There was a steel workers strike. Truman said that he had this inherent power of the presidency to be able to nationalize the steel mills. And the court came in and said, no, Mr. President, you do not. You're in violation of the Constitution. You're in violation of the Taft-Hartley Act. And one of the fun opinions is a concurring opinion written by Justice Jackson, who comes up with a three-pronged test for executive power. And when the president is acting in concert with the Constitution and Congress, that's when his power is at its highest. When the president is acting contrary to the Constitution or the Congress, that's when his power is at its lowest. And when the Congress and the Constitution is silent, that's when we've entered a zone of twilight of presidential power, or as people call it today, the twilight zone of executive power. And there's a lot of gray area in that. And I got to steal a line from Dr. Adler, who was supposed to be your scholar for this, so sorry about your luck. He said, nature abhors a vacuum. And I have to explain that to my students when I use that. So if Congress is not going to use its power, the president steps in and does that. And there are multiple examples throughout history where Congress has not stepped in and the president's willingly stepped in and taken that. Mark, could you scroll down for me, please? This is from John Yoo. John Yoo worked in the Office of Legal Counsel for President George W. Bush, and he is now a professor at Stanford. And it talks about the centralization of authority, and the president alone is particularly crucial in matters of national defense, war, and foreign policy, where a unitary executive can evaluate threats, consider policy choices, and mobilize national resources with a speed and energy that is far superior to any other branch. I might personally argue with Professor Yu on that because Japan bombed Pearl Harbor on December 7th, 1941, And we had a declaration of war December 8th, 1941, and travel being what it was and technology being what it was. That's a pretty quick turnaround for Congress to give the president a declaration of war. So I would like to take that quote and take it back to some of the framers that feared that we were making an elected king with the military, and see what they would have to say to Professor Yu about that. I think, Mark, is that the last one? No. Oh, the last quote here from John Dean. John Dean of Watergate fame, a more current picture on the top left and an older photo circa 1972 down at the bottom right. And each national crisis has left the nation a little less democratic than before. And Justice Jackson wrote about the idea of the president being allowed to have what's known as emergency power. And he says, if you believe that the president is going to have emergency power, well, the president is always going to be finding emergencies. And so he thought that was a little suspect, and that was many years ago. So that's not a current quote, and obviously we have that issue these days. Now I'd like to get you guys in the breakout room here if I could. So Mark, if you could go to lesson 23, that's good. So it's argued about, sometimes argued that 2+ centuries of American experience have been characterized by general drift of authority and responsibility toward the executive branch. In fact, the preponderance of power has flowed over time. Yeah, it's the same thing I've talked about. So the administration of Franklin Roosevelt, Lyndon Johnson, Richard Nixon were marked by increased assertions of presidential power. There are several reasons here, and it gets down to Hamilton again in Federal 70. Energy in the executive is a leading character in the definition of government. Jefferson contended the circumstances sometimes occur, and go on. So you can read that. And if you would scroll down for me, this is what I would like for you guys to address in your breakout room, right? So keep going just a little bit more so we can get that up there. The Constitution lists 3 formal requirements for the office of the president: natural born citizen, resident of the United States for 14 years, and at least 35 years of age. And so once you go into your breakout rooms and think about these informal qualifications. So this is what I'm just curious as to what, here we are, right? What are the informal qualifications that you think a president should possess? For example, should he be well educated? I always ask my students, so you should have a college degree. And oh yeah, I should have a college degree. I said, well, should it be in like HVAC maintenance? So you play that role with that. Have a previous government or military experience. Be charismatic, articulate, personable. Why? So we're going to come back and compare our lists and see if how similar or dissimilar we would be. So let's take about no more than 10 minutes max, I think, Mark, if you want to put some folks in breakout rooms and let them just discuss the informal qualifications you guys believe for a president.
So we talked about just kind of starting off with some of the major things. I think we talked in a general consensus that we agree that presidents need to be they need to be articulate. They need to be able to approach the entire populace and speak for the entire populace and speak to the entire populace. And that, a president needs to have a set of goals and an agenda that he can or she can correctly communicate to the people. And we didn't really talk about anything other than that. I mean, we kind of dabbled around the idea of education. And then Tim mentioned, do we kind of have some of these de facto requirements? And he mentioned religion specifically. And we were kind of jostling back and forth, do we kind of expect our presidents to be religious? And as the conversation was going through, I think it was a very interesting point. And I think that you could probably say that we have lots of de facto requirements for our presidents, not just a religious test. I think there's lots of cases where we think that a president needs to have some type of qualification before they can enter in, before they're going to get our vote per se. And religion is definitely one of those, I would argue. So it was a good discussion.
I wanted to just add on what Pinal had said too. I thought was really, I enjoyed was that the idea we have a president that's humble enough that he's willing to learn, because we know that the president can't be an expert on everything. So he's going to listen to his cabinet or his advisors, because they will bring in their expertise. And I thought that was an interesting point. So thanks, Robbie.
All right. So group 2, that was Shayne Klein. Shayne, do you want to address your group's discussion?
Sure. We talked about a lot of the same things that group 1 talked about. We also talked a little bit about some of that some folks as students had raised issues about health qualifications. And we talked a lot also about how, what we are looking, so much of what we think about what we want in a president is framed by the experience we're having right this minute, right? So it's hard to get out of our own current frame and think about what we want. But Ryan also brought up something that I wasn't aware of, that Washington State just passed a bill through one of their one of the branches of their state legislature to require anyone to be on the ballot. They have to have released their last 5 years of tax returns. So again, that way in which we're sort of stuck in our own moment and impacted by that as we think about this issue of qualifications.
Great. And then Tom, do you want to go ahead and share group 3?
Well, I would, but Peg is insisting that she do it.
Oh, sure.
So Peg, you're on. Constitution 101, Peg, what did we talk about?
Well, I got my arm twisted a little bit with it. I just want to clarify that. But we overlapped considerably with the ones that have already been mentioned, but they were things like the person coming in should have some government experience, or at least demonstrable knowledge of how government works and perhaps knowledge of the Constitution. Somebody else mentioned humility in one of the other groups, and we would concur with that too, because one of our people mentioned that the person should be willing to surround themselves with competent, well-qualified aides and people, and then also be willing to listen to the advice that those people present to him or her. That the president should have integrity, and there should be transparency. The tax returns issue was mentioned in our group too. They should have the ability to work with a demonstrable ability from past history of evidence of their ability to work with people of all kinds in a very diverse population, and to be able to work for the common good and demonstrate an understanding of that principle. And then also some evidence of good judgment, hopefully specific examples in their past, whether it's personal or professional or whatever, where they could show how they approached a very difficult problem and how they logically reasoned their way through that, and can then explain, how they came to their conclusions, and they could demonstrate in that case good judgment in reasoning and logical thinking. And if you guys want to jump in, I'm running out. That's all I can think of. Am I missing anything?
No, Peg, your first experience in front of the whole group, and I think I'm well qualified to make this statement, was fantastic. That was very, very good. Thank you, Peg, for the excellent overview.
You're welcome. I apologize for my voice. I've got some throat problems.
Coming through loud and clear.
Okay.
Great job.
So, Chris, we can turn it over to you for the closing remarks. It looks like it's
about time. So I was going to have us look at an article written by Dr. Adler. There's a fantastic piece that I share with my students, and I steal a lot from him because there's no need to reinvent the wheel. And actually, you know what? Joan said this in our group. She said, it's not really the president that needs to be educated; it's the people that need to be educated. Which I thought was absolutely correct. And you see a rebirth of civic education and people wanting to know more about this. So the people that are here tonight speak to that. And Dr. Adler has a term that I use called Madisonian monitors, that we all have to become Madisonian monitors, and the idea that we return to these first principles, these constitutional principles, and what does that mean? And I think it serves all of us well to be able to, if we want to talk about, what is executive power, what's legislative power, and what is the power of the courts? How does our government work? And all of this, it behooves us to go back to examine these first principles, and everybody should be a Madisonian monitor. So that's my closing words of wisdom tonight. Thank everybody, and Mark, that's all, folks.
Okay, Bob, do you want to take us out with a last remark or two?
Yeah, thanks, Mark, and thanks, Chris and Shayne tonight for your presentations. They seem to go faster than I think. That's good. Next week we've got the Bill of Rights. Big discussion about how it became about. We can't cover all of it because of our time frame, but we're going to deal in my session, the first session, generally speaking, about privacy and the Fourth Amendment. And then in the second session, Chris is back on with the First Amendment, which is huge. There's a lot of stuff in there. So I'm looking forward to it. I know that with the We the People program that kids love Unit 5, and I might just jump out there and say I think people in general like Unit 5 because it deals with our rights and how are they limited or not so limited. So thanks a lot, everybody, for tonight. And we'll see you next week, same time.